the purpose of this course today is an overview of estate planning. What are the documents and how they work, and who needs estate planning. And then I'm going to teach you how to really mess up your estate planning so you're unhappy, or avoid that altogether. Okay, so let me get here the learning objectives to understand why comprehensive estate planning is needed. What are the 4 essential legal documents for what I call comprehensive estate planning? It's not a piecemeal, it's not just a trust. Who needs comprehensive estate planning? And what can go wrong if proper planning is not done? So the 4 documents that I normally include for comprehensive estate planning are a revocable trust. And when I'm working with a family, a couple, we have 1 trust when we start, and we do 2 pour-over wills.
You need to advance the slide.
Okay, it says comprehensive estate plan. It starts with revocable trust.
No, you need to advance the slide.
Is that better or not?
No.
I'm not seeing it. I am on my screen. I've got a comprehensive estate plan with a revocable trust on the first line.
No.
I cannot see my screen through Zoom. Oops. I wish that I could. Okay, I'll advance the slide. It's not advancing too well. Now, does that show a diagram with 4 circles?
No.
Okay. Okay, how come I can't see that? Okay.
Because you're looking at participants. If you did your slideshow.
Okay, I am going to.
Rex, would you like me to pull up?
I've got a backup. I've got a PDF. Now let's see what I have with this method. Okay, so is it moving? And I have a drop down. I got it here. Let me turn this part off.
Probably me.
Actually, that looked like one way to advance, but you never clicked on the second one.
Okay, is it say learning objectives?
No. Bring that thing back that you had up, because it was highlighting different slides.
Okay. What I had here was the PowerPoint. And I wish that I could see my own feedback from Zoom. I can't see anything, so I don't know what you're seeing, so you help me out. This does not say learning objectives on yours.
No.
Okay, let me try something else. I'm going to move monitors. Does that say
Yes.
comprehensive estate plan?
Yes.
And now, does that say a diagram with 4 circles?
Yes.
Excellent. So I combined my monitors, and hopefully that's all I needed to do. All right. Sorry about all the confusion. So we're going to cover the essentials, the overview, and then I'm going to show you how to mess up your estate plan. We were going through some of the documents, 2 pour-over wills, 2 durable power of attorney for asset management. And the definition of durable power of attorney is a power of attorney that stays effective after a person becomes incompetent. And then we prepare 2 advanced health care directives, 1 for each spouse. Now, does that? Okay, so that's basically what we just talked about, the documents, and my little motto for estate planning is don't leave Earth without it. So if you get a ticket to go to Mars, do your estate planning first. Okay, so who needs estate planning? My view is that if you own a house or real estate in California, you should have a trust. And the reason is if you have over 166,250 in assets, then your beneficiaries are going to have to do a probate to get the assets in their name. This you'll see in a lot of publications still says 150,000, and it was upgraded at the beginning of this year. All the assets that need to be titled, well, cash would be on a bank account, stocks, antique, business ownership, real estate. The items that you do not include in calculating for a probate are pension plans, IRAs, 401ks, and that's because they have a designated beneficiary that is by contract. And you don't put them in your trust, and pensions, you have to be careful about directing them to go to your trust. Generally, it's better to an individual for the better tax benefits. Life insurance is not included for probate, and annuities are also not included. Now, when I say things are not included in probate, they are included for estate tax, but very few people have to pay estate tax anymore because you don't start paying estate tax until 11,580,000 of assets. So if somebody has, like, say, a young person, 20, 30, 35, something like that, and they don't have many assets yet, it does make good sense just to have a will. It's not going to cause any problems. There's not much of an estate, but it does direct your beneficiaries on who is supposed to get what in terms of asset distribution. When you don't have a will or a trust, then you get into intestate succession, and you hear about this thing called a table of consanguinity. Well, consanguinity, the Spanish word for blood is sangre. So it's the consanguinity is bloodlines. And there's a big chart that is rather surprising sometimes on where the assets go if you don't have any type of estate plan. Okay, well, what is a revocable trust and what does it accomplish? It's also called a living trust. Sometimes it's called a family trust, a lot of different names. And it is touted to avoid probate, which it does. And your beneficiaries are able to get their inheritance faster than through probate because probate takes 10 months to 18 months. And processing a trust administration, you don't have to have court supervision or the court hassles. And you have an easier ability to manage the assets during the trust administration process. The trust is basically a document. They call it a declaration of trust. Some people think that a revocable trust is an entity. It really isn't. It's a way of holding title. It's a potential entity. When I consider something being an entity, it has to have a federal ID number from the IRS. Revocable trusts do not have federal ID numbers, and sometimes your banks will ask you for one, when you're titling your accounts at the bank, and you just tell them, I don't need an ID number because I'm using my social security number. And the trust is basically a contract between the settlor, the persons that make the trust, and the trustee who holds bare legal title, and then the beneficiaries who receive the benefit of the agreement. Some people call it a contract. It's not in fact a contract because there's no consideration, but it is recognized under the law. You have faster distributions from a trust than having a probate, and there's a lot less frustration and fees and filling out all kinds of forms. You know, some people think that attorneys like to do probates. They're a real nightmare in terms of the volume of paper and the details that you have to fill out in order to keep the case processing. And they have a thing called probate examiners, and you turn in all your papers after you filled them all out, and then they go through them with a fine-tooth comb and say, you didn't dot an I, you didn't cross a T, you can't do this, can't do that. And the whole probate process is frustrating even for a law firm. So I don't recommend it, but I don't think that everybody touts the trust as the only thing and to avoid probate, but there are other methods where you don't use the trust and transfer assets, such as designated beneficiaries, having a pay on death account at a bank or stockbroker. So those are some of the things. Joint tenancy, which you can use, but there's some caveats on problems with it. So the settlor creates the trust, and you end up just retitling the asset in the name of your trust. A lot of firms have gotten into the practice of using the client's first, middle, last name, the wife's middle, first and last name, and then the date of the trust, and it makes a huge problem for writing out for the successor trustee, putting all that gibberish on a signed statement. Frequently, we will use a generic name for a trust that the client likes. We've done one, was Crystal Trust. They liked doing rock collecting. We did another one called Jane's Retirement Trust. The clients had one daughter, Jane, and so they named it in her name and call it her retirement trust. So you can use any name you want. You're not stuck to your name. You just want to have it so no one else can confuse it. But that's usually not a problem. Even if your name was Joe Smith, you put comma, then date of trust, and that usually is enough to keep it from getting confused. Okay, so a metaphor for the trust process is consider all your assets to be in a pod. The pod is what they use oftentimes for moving people these days, and basically there is a similarity that you put all your stuff in the pod before you move. And that's the same thing as a trust and titling all your assets in the name of the trust. Then after you pass, your assets take a ride to their new owners, beneficiaries. Similar to a trust is held up until the administration is done. And trust administrations can take anywhere from 2 or 3 months to longer, up to a year, but usually less than that. You just have to find out what all the legal requirements that you have to comply with. Okay, now, if you leave things out of your trust, it's expensive to go back and get them into the trust. So if you have a lot of assets that are outside the trust and it causes a probate, well, that's going to be expensive to get it back into the trust. hopefully the pour over will tells the court that it belongs in the trust and they'll cooperate and change the title into the trust. And there's a process called the 13100, that's the probate code section. If you have assets less than 166,250 that are not real property usually, you can use this statement. It's a statement from the beneficiaries stating that we're not doing a probate, we don't have to, our assets are below the value where a probate is required, and it's notarized. And nice thing about the law is if you give it, we just had to do one for a credit union. They wouldn't allow the beneficiary to get the money. So we did the 13100 declaration. It's a standard form, notarized it, and gave it to the credit union, and then they allowed her to get the assets. In that statute and on the form, it tells the person you're giving the form to, if you do not follow and conform to me being the person entitled to these assets, and we have to bring a case against you or your company are liable for all attorney's fees for requiring us to go through an unnecessary legal procedure. And usually banks have a front desk person, and they call back east someplace where they have somebody that knows what they're doing. And that 13100 is a nice procedure to use when you have a few assets that are not indicated in the name of the trust. Okay, so the will. What good is a will? Well, as we said, it's not your centerpiece of an estate plan unless you have very few assets, and then it'll work fine. If you have less than 166,250. We call it a pour over will because, oh, I can't believe that. Oh my gosh. Pour over will because anything that it says, if you have any asset that's governed by the will, go put it in the trust. If the trust is invalid for any reason, do what the trust says anyway. So it's very a perfunctory document, only a few pages, and it basically points back to the trust at every step. One of the advantages that everyone should be aware of is a will is the only place where you nominate who's going to be the guardian of minor children. And I say nominate because when both parents pass away, if that occurs, it has to go to court to get a guardian appointed, and it is a nomination, and the judge will consider what the parents wanted, but they're not bound by it, but they usually go along with that process. So if you find out that a person passed away and they say, oh my gosh, we've got all these assets out of the trust, now we're going to have to do a probate. And you find out that their retirement plans, life insurance, or annuities, remember I said that those are not counted for probate. And it causes quite a bit of confusion in a trust or state administration because each of those vendors operates independently. They don't really care what the trustee says or even who they are or who the executor is. They are bound by the contract with the person who bought or invested in the retirement account, and then they're responsible to the beneficiaries. I do suggest on retirement plans that you name a person or persons to be the beneficiary and not the trust, but it's sometimes a good idea to name a trust as an alternate beneficiary. And then we have a pronunciation guide here. As you know, for a trust, you have a settlor and a beneficiary. But I just wanted to point out, never make the mistake of calling it person who makes a trust is a willor, and the beneficiary is a willee. I just hate it when that.
You're such a silly
Okay.
guy, Rex.
That's funny.
I can't help it. Okay, probate means lost time and avoidable costs. So I see a lot of presentations on estate planning and they just say that probate has absolutely no benefits. There are benefits to probate. And if you ever need to get a decision from a dead person, a probate is your legal procedure, because the state of California only trusts impartial, responsible people to sign for a dead person, and that would be the judge of the probate department of Superior Court. As I mentioned, it goes usually 10 to 18 months, if not longer. It's expensive, and the executor gets a fee and the attorney representing the executor. I get asked oftentimes whether a individual beneficiary can handle their own probate. And I know my view is biased. However, the amount of paperwork and forms and details involved in a probate will create a huge amount of frustration for anybody that's not trained in it to get through. And sometimes the court clerks and probate examiners are not that friendly to self-represented people. And unfortunately, it's quite complicated. And California is one of the most complicated states. Some states, like we've had clients do probates in Arkansas and some other places, and it's not that problematic of a procedure, like Texas, for example. But California makes it a problem. For example, this is the probate code. So you just study that for a few days and then you'll know how to do it. One thing I wanted to point out, because there's a lot of confusion about it, is that when you hear about the probate fees that law firms are allowed to charge for probate, I wanted to point out that the real statute says that is a maximum. And I hear people saying, no, that's the required fee. No, it's not. It is negotiable. And this is the legislature saying, no, this is the maximum. However, most people end up with that amount, but it is not required. Okay, some of the benefits of probate. You have to dig far for them, but there are some. It cuts off liability for the executor and the beneficiaries. So let's say, for example, that the decedent had went out and bought a lot of home appliances, unsecured debt, and then they passed away. And during the probate, the creditors never filed a creditor claim. That liability, as soon as the probate is over, that liability is expunged and disappears. And especially there would be times like hazardous waste on real property is a huge legal problem. They have a thing called CERCLA that everybody has personal liability if they even get close to owning hazardous material real property. And if I had a trust that had contaminated property in it, I would do a probate just to get the limitation for the executor not be tied up in all that. So if there is a liability issue, think of probate even in a trust. And the probate code covers wills and it covers trusts. Trusts are not required to file in the probate court. However, you always have a right to. So if you have a problem, let's say the trustee thinks that all the trust money is theirs and they decide they want a lavish lifestyle and spend all the beneficiary's money, then the probate court is there for you to help protect the beneficiaries. Okay, so the next slide, this is a probate calendar I got off the internet, and I chose an estate value of 2 million. I mean, with the houses in the Bay Area being 900 to 1.5 million, I figured that a $2 million estate is not that unusual. So I plugged it into this calculator for 2 million, and the probate fees, this is the statutory probate fee, is 4% of the first 100,000, 3% of the next 100,000. Then we go 2% of the next 800,000. We're at $1 million at this point, and the 1% of the amount for the next 9 million. So in this example, with a $2 million estate, we have a probate fee, a maximum of 33,000, and that's a lot of money. Administering a trust would well more than likely be less than that and take less time. One thing that I want to point out about the statutory fee is that that's what most people would assume that the attorney gets for handling the probate. However, the executor or personal representative also can claim the same amount in a probate. So if you have an executor or personal representative who is not a beneficiary and they're doing all this work, they have a right to claim another 33,000 for their compensation.
Need to take a break for answers.
Okay.
Rex, we have a few questions before they get too long. Could we
Yeah,
jump in
let's
and ask
have
a
some
couple?
questions.
Would
Yeah,
that be
I'd like questions.
Sure. Okay. Let's see. Can you have a trust if you don't have a social security number?
Yes. A trust is not federally regulated, it's state. And generally when you have social security numbers, you're talking about federal requirements. What you would need to have is assets, and you'd have to put the title of the assets in the name of a trust. But I have never heard of anything requiring that. Fact is, the only time that we need a social security number when we're doing, well, trust administration, if we sell real property, we need to show the social security number so they can get a 1099.
Okay. If there are a few accounts left outside a trust, but it's under $166, does the client have to file a small estate with the court?
Okay, the break point is 166,250, and if it is under that, you can use several small estate procedures. One of which I mentioned is the probate code section 13100 declaration, and that usually is sufficient. There are two other small estate procedures for real property. I think one of them is if the real property is less than 50,000, I don't recall the exact number. And there's another one for property below, I believe it's 20,000. And we're working on one now where the decedent died about 15 years ago. His daughter now has rights to the property, and we have to do an appraisal. We turn in the appraisal to the court, and they issue a decree stating that it does qualify for this small estate transfer. And then we need to record that judgment in the county where the property is located to change the title. So there's, in California, I'm aware of 3 different small estate procedures.
Okay. A follow-up to that is, Could we get a copy of the 13100 declaration so that I could send that out to attendees?
Yes.
Okay, I will make a note of that.
Yeah,
And
I'll
then-
need to make a note of it also. It's a standard form and usually standard. You can add other things to it.
Okay. And does the 13100 get filed anywhere?
No, it's generally because you're not using it for real property. You don't have a recordation. It is notarized like deed or something of that nature, but you give it to the third party. Say I'm Bank of America and the decedent had an account at our bank for 150,000. They get a 13100 declaration along with a copy of the death certificate and a copy of the trust and or will or both. And that should be enough to make the transfer. But there's no place to record that because it's not a procedure to use on real property. It's only for personal property and intangibles like copyrights, patents, or music rights.
Okay. And can a sister and a brother create an estate?
Okay, the question's somewhat ambiguous. I'm going to rephrase it. A sister and brother can prepare an estate plan. Any two persons can create a trust, or each of them can have a will. And there's no problem with that at all. Each person contributes their assets to the trust. A sister and brother, sometimes they want separate trusts because perhaps they'll get married in a couple years and then they start getting community property, which starts getting a little confusing. It is a good idea to keep things separate, oftentimes for inheritors, to keep their assets in a separate trust to make sure it doesn't get confused as community property. But a brother and sister, there's no problem at all. I would use one trust if they wanted it and two separate wills because their assets on a will, you don't usually combine them into wills anymore. There used to be a process where they had contracts to make a will and they were tied back and forth. Nobody really does that anymore.
Okay. Just to be sure there are no problems, is it advisable to include retirement accounts, say rollover retirement accounts, in a trust, even though a designated beneficiary was made, so long as there's no conflicts between the two?
There is a conflict between the two because a trust does not control a rollover IRA. What is normally done is you do the rollover IRA to the beneficiary and you label it as such. You don't usually mix it in with another account. The problem with naming a trust as a beneficiary of a pension plan is the elections that you get as an individual are not available to a trust. For example, there's a procedure where you can do a rollover, and if the person's, let's say they're over 72 and they're required to take a minimum distribution, you can roll that over, not have to take it out and get taxed now. And then you have to take the income over 10 years. A trust cannot do that. And if generally on a pension plan, if a surviving spouse is the beneficiary, they have the right to just roll it over without taxation, and a trust does not. I had mentioned that if someone needs an alternate trustee or alternate beneficiary, a trust might be an alternate. For example, if they have one child as a beneficiary, you could name the trust as the alternate beneficiary. But it's a misnomer to assume that a pension, an annuity, or life insurance is in fact owned by the trust. A pension is already a trust. And it's not part of your regular trust, although it it is permissible to have it as a beneficiary.
And which would be first rule if different designees designate?
Could you ask the question again?
Why
I'm not
would you
sure.
include it if it's the same beneficiary?
I'm not sure, but I think you're saying you have one beneficiary designated, and then what's normally done is if that person's not alive or just claims the asset, then it goes to an alternate. And frequently you can have one designated beneficiary, then you have an alternate, or sometime I'll see, like, say there's 3 names on a designation for a pension or something. So yes, alternates are fine.
Okay. And can you share the link to the probate calculator? Is that something I can get from you and send out to attendees?
Yeah, it looks like losangeles.trustlaw.com. If you
All right, well,
enlarge that, I can send it to you, but it's also on the screenshot.
I'll
And
go
there
ahead
are
and get that
several
from,
items.
I'll get that from you tomorrow, and I'll send it out with everyone's
Sure. There are,
certificates.
this is only one of them. I chose this one because it gave a better example. But you could do a Google search for probate California calculator or California probate, you know, because
Mhm.
California, everything you do with wills, trust, and estate, you're in California. And when you get national text or national advice and things like that, generally it gets changed once you look at California.
How do we
yes,
know?
that is available.
Sorry. How do
Go
we
ahead.
know
How do we know?
which plans like IRAs, retirement, 401k, accident, or life insurances to put into a trust? Or what's the best thing to do?
Don't put them in. You just.
Okay. Those assets that you were just naming are not controlled by a trust. They are controlled by a contract between the person who hired the vendor and the vendor's legal department. So you have people trying to transfer a pension into a trust as ownership. It just doesn't work. It's already a trust. So what you have to do is think of it in terms of what is a designated beneficiary. And an example, I have it later in the material, but we had a client come in and we're looking at the designated beneficiary, and I saw a name I didn't know. The woman had a previous marriage, had gotten divorced for a period of time, and now was involved in this long-term marriage, and she forgot to change the designated beneficiary to the boyfriend in the interim, and the new husband didn't know about it. So she blushed quite a bit, and they worked it out and got the beneficiary statement changed.
Okay. For joint bank accounts, should the beneficiary be the trust? Also, how does the durable power of attorney affect married spouses with separate and joint bank accounts?
Okay, first one had to do with joint accounts, how to do them, or
For joint bank
There's two
accounts,
questions.
should the beneficiary be the trust? Can you make the trust the
okay,
beneficiary?
when you have joint bank accounts, what the concept with joint tenancy is that when one of the parties dies, it automatically goes to the survivor. So it wouldn't be going to the trust. It would go to the survivor if it was joint. And with the banks, you can do several things. You can do pay on death, which avoids probate. It goes to a designated beneficiary. But anytime you use the word joint in an ownership, be careful, because you can have another document like a will or a trust, and the property is held in the name of joint tenancy. And then when they die, one person, the joint tenancy prevails, and everything you planned in the will or trust does not happen. It has no effect. So be careful on using joint. Oftentimes you can put, like, say if there's one person and you have another signatory, that's okay. That's not a joint account. Now, the durable power of attorney question, if you could rephrase that again so I can catch up with it.
How does the durable power of attorney affect married spouses with separate and joint bank accounts?
Okay. The durable power of attorney, first of all, durable means it survives person's incapacity. If they get Alzheimer's or something like that, then the agent takes over, and it's only for assets that are outside the trust. If a trustee becomes incapacitated, they cannot be a trustee of the trust. So then the successor takes over. On the durable power of attorney, every asset that's outside of the trust can be controlled. Usually the successor trustee and the durable power of attorney agent are the same people. Now, if one of the spouses becomes incapacitated and they have separate and joint accounts, the agent under the durable power of attorney has the control as if they were in the shoes of the person who became incapacitated. So they cannot control the other spouse's separate property. They have a right to control the community property or community accounts. When you do an estate plan, you want to have separate durable power of attorneys for asset management. And the other thing to be careful with on those documents is I don't make them effective when we create them and the client signs them. I'm always worried that if you give someone a right now to handle the client's finances, it's almost like a license to steal, because they have a right to the assets right then. And if somebody took assets from a person who had a durable power of attorney for asset management and they were still competent, the police are not going to spend much time on it because the person gave them the right to do that. What I do is prepare what I call a springing durable power of attorney, where it is not effective at all until a doctor signs off and certifies that the person is incapacitated, can't manage their own affairs. And then with the doctor's statement, that is the activation point for this springing durable power of attorney to come into effect.
What do you do if you are the executor of an ongoing trust, life tenancy, with remainderman rights to successor trustees to heirs? Do you want me to repeat?
Okay. No, I got it.
Okay.
First of all, the term is not executor, the term is trustee, because if you were an executor, which would mean you're in probate. But I think the question revolves around the distinction between a current beneficiary and a remainder beneficiary. Because frequently what we'll see is, let's say husband and wife, and either a spouse passes away, and it says in the trust the survivor can have the income, and then the remainder goes to the children or someone else. And that is a problem at times, because what's good for the income beneficiary is usually bad for the remainder beneficiary. And so in court accounting, which we teach, it's always a trade-off because they're opposing interests. I don't know if that answered the question or not.
Okay. There's a follow-up. Do you keep a new trust separate or combine them?
Okay, when you say a new trust, what is frequently done, I'll get clients in and they'll have a trust. It's a 1995 trust, and all the clauses are out of date. They're not on current law. They create an AB trust for inheritance tax that is not going to impact these people. And what we do is we revoke the entire trust, keep the name the same so we don't have to change title of the assets, and do an amended and restated trust. Now, if you have two trusts, you'd have to look to see whether you were able to combine them. It usually occurs where there's one trust instrument, and then at some certain time it splits and there are separate sub-trusts. And so that's going the other direction and dividing out. But combining two trusts, I have trouble visualizing a beneficial reason for doing that.
And on his message here, all those questions, we're never gonna get through this.
Can, I'm sorry, can a boyfriend, girlfriend planning on marriage create a joint trust before marriage?
Yes. That's a reasonable thing to do. And there's not really any downside to doing that. Community property has not started into effect yet until their marriage is recorded. But I think it's a good idea. In the material there, I have an example of a couple where the woman moved into the gentleman's house, lived there, was long-term relation. The man passed away, and the police would not let the woman back in the house at all. She couldn't get her clothes. She couldn't even get a toothbrush. So if you have a trust where it's held in title and it shows in the trust that, in this example, that the woman has a right to be the successor trustee, then that would be avoided. But I think that's a reasonably good idea.
So Rex, I'm wondering whose social security number goes on that trust?
On a revocable trust, with most bank accounts, what happens is the first name the bank picks up for 1099s. So you can put male first or female first, but it's likely going to go into one social security number. If you have a joint bank account, a joint stock account, they're not going to issue separate 1099s. And what I do when I'm doing tax returns is I will include the entire amount on the person's return that got the 1099. And then I do a reversing entry and say less amount distributed to other social security number 1234, and then back it out so that the tax is proper. But the answer is the first one, whoever's on the account.
They ought to just get married right away and have a big wedding later, to me.
The same thing would happen. I mean, it's still going to be the first person on the account, and a big wedding, you know, may deplete some of their assets, but might be a lot of fun.
Rex, can we go back to slides and then we'll come back to the questions again?
Sure. So we'll continue on with the slides.
Yes, please.
Okay, be happy to. Okay, the durable power of attorney. We're talking about a document that only becomes effective on incapacity in my case. The word durable means it survives incapacity. Normally, when somebody's incapacitated, they can't contract. Anything they sign is invalid. And this particular power of attorney is a creature of the legislature. There's, and the durable power of attorney terminates on death. The only place I know is Switzerland that allows a durable power of attorney to go beyond death. So it's a useful document, it's required. We generally put the trustee and the agent under the durable power of attorney as the same persons. So they're handling the trust and they're handling the assets outside the trust. Okay, an advanced healthcare directive. they're primarily, first off, designed for use in communicating with medical personnel if you become incapacitated. You get in an accident and can't talk, the hospitals are really worried about giving any medical advice to someone they're not supposed to, the HIPAA laws. So it's important to have a advanced healthcare directive. In fact, most hospitals will not allow you in for an operation unless they have one of those on file. In addition to the advanced healthcare directive, there are other things that you may consider to include regarding perhaps resuscitation, organ donation, either for science or for other medical reasons, and then other end-of-life decisions. Do you want cremation? Do you want burial? And I haven't looked into it too much, but there's a new chemical form of cremation, and that's an option. It also includes the decision that the person makes if they want to have the plug pulled if they're in a persistent vegetative state. But I wouldn't go too far on that, because you might want to say that they're in a current vegetative state, but there's a chance they might come back in 2 or 3 weeks, which has happened. So you don't want to be too quick on that particular decision. Another document you might consider in this regard, it's not an advanced healthcare directive, but it's called a PULSE. And it's a do not resuscitate order that you don't really want CPR or other heroic efforts to be done on you if you are in need. You want to die naturally or whatever the circumstances. We have an example here in the office where somebody had a pulse. They went into the hospital and had a heart attack, and on the floor, the medical personnel did heroic efforts and survived, made the person survive. And later they were quite happy about that, even though they had a pulse to begin with. So you have to take it with a grain of salt. And the way that those usually work is they're on like a pink color paper, and you put it on the refrigerator. So when emergency personnel come, they look at the refrigerator first to see if there is a pulse, and then they do what was requested of them. This particular document is not done by a law firm and the client. The pulse has to be signed by a medical doctor, so they are fully briefed on the impact of that, the form. But one of the things I want to point out is getting funeral arrangements before death and casket and all that. It's really recommended because it puts a large strain on your survivors to have to make all those decisions in addition to grieving. And if it's all taken care of, it makes it a lot easier for those who follow. Okay, so here's different types of estate plans, or what happens. If you have no estate plan, what happens? Well, one thing I see people do is joint tenancy. That works, it gets to the survivor, but there's a tax problem. If you inherit property, you get a full step up in basis when you receive property. And basis means what you would calculate if you sold it at a gain, what would you subtract for your cost? And in a joint tenancy, you only get half a step up in basis, which is a tax disadvantage. And as I pointed out, it's not controlled by a will or trust. I've seen other cases where they'll put a son or daughter on title, and that is problematic, especially one that I saw where The son was on title. He had a trucking business. He ran over somebody and had a huge liability. And he got put on mom's house, which put her whole house at risk. There's also a problem with children from previous marriages getting unequal distributions from not having an estate plan. And we already talked a bit about probate. So another option for estate plan is the person writes their own will. Is it valid? Did they follow the state requirements to make the will valid? Is it complete, unambiguous? And on a will, what happens if there's real estate? We talked about probate. And what happens if a person wants to update it? And then after they pass away, the beneficiaries may have a question if the person was unduly influenced in the making of their will. California does allow holographic wills, which you write it all in your own handwriting. And a couple of them that I thought were quite interesting was this one guy wrote out his will on a wall. And so they wanted to probate the will, they had to bring the wall in to show that the will was written. But, and you know, a will is easy to do. There's a statutory will, but the requirements have to be met. Otherwise, the court will not accept the will. Okay, another choice for estate planning is going to the internet and downloading a bunch of forms, and they say that that's a good estate plan. Well, there could be some problems. Important paragraphs about your wishes might not be included, and there might be mistakes in filling out generic forms. The whole area of wills and trust is usually so foreign to people that even given choices, they're not really getting a full understanding of what their decision does, and that's a problem. Another problem with the internet forms of trust that I've seen is they never get around to transferring the title to the house or to the other property into the name of the trust. And when we find that, and we make it available to members of the people on the webinar here, if there is a trust that does not have the house or real property in the trust, for a fee of $250 plus the public filing fee, we will take care of that for you and get that trusted, titled in the name of your trust. Another option for estate planning is to hire an estate planning attorney. You get exactly what you're looking for in terms of all the paragraphs. There's no probate fees, and the attorney's fees to prepare an estate plan are vastly less than would be required if you had a probate. You get all the necessary documents, and there's a lot of unique situations that an experienced estate planning attorney can make happen that are not within the generic type forms. So you get peace of mind for your beneficiaries. So here's a polling question. What is a comprehensive estate plan? Feel like you're back in school again. Is it a revocable trust and a will? Is it a trust and a transfer your house to trust? Is a comprehensive estate plan all necessary documents, revocable trust, pour over will, DPOA? Or is it a revocable trust, pour over will, durable power of attorney for asset management, and advanced healthcare directive? Your answer, I'm sure, is D. Okay, now I'm going to show you how to mess up estate plans to get unintended consequences. And this happens way more than you think. It's quite frequent. One mistake, dying without a will. Abraham Lincoln was shot on April 14th. 1865. That's the day before the end of tax season, although they did not have income tax back then. And he had an estate that today would be well over $1 million, and he had to have the estate administered by a Supreme Court justice. Other people who have died without wills, we've got Prince, died with a estate of $300 million. Sonny Bono died, as you know, in a skiing accident. He had an estate worth $1 million to $15 million. He had remarried to a new wife after Cher, and he also had a separate love child. After he died, Cher filed a claim in the probate court for unpaid alimony. She had to have that money, even though she had an estate of as much as $300 million. Pablo Picasso died in 1973, and he had assets in multiple countries. It cost $30 million to get his estate taken care of. James Dean died young without a will. Martin Luther King was assassinated, died without a will. When his children became adults, they've all fought tooth and nail about the legacy in court, creating a lot of costs. One of my favorite artists, Jimi Hendrix, died in 1970 at age 27, did not have a will. He probably would have wanted his brother, Leon, to receive part of his estate and perhaps his dad. What happened was his dad, Al Hendrix, I call him Big Al, received his entire estate. Then Big Al got remarried, adopted another child, Janie Hendrix, and when Big Al died, all the money was destined for Janie. So Leon, the brother, was cut out. And what ensued was 45 years of litigation. You know, that's longer than the normal probate. But they finally came to an agreement 45 years after his passing. So that I'd have to call a big estate planning failure. Warren Burger, former Chief Justice, Supreme Court, had a will, and he said, my executors will pay first all the claims against my estate. He spelled executors wrong, but I won't fault him for that. I'm not a good speller. And it was reported that he had created a significant estate tax liability that could have been avoided. B.B. King died in 2015. He had 11 children. He was a busy man. And his children have been fighting for control of the assets ever since he passed. Most of the time, the claims from the children have been thrown out from the court. This I mentioned previously. We had a live-in couple where the male partner died, and then the surviving spouse could not get back in the house, and that would be an estate plan failure. Not planning for estate taxes would be an estate planning failure. Keep in mind, I want to point out that avoiding probate has nothing to do with estate tax. If you avoid probate, it does not mean you escape estate tax if your estate is that large. So the Wrigley family ended up not planning properly for estate tax. They ended up getting sued by 4 governmental tax agencies, the IRS, California, Illinois, and Wisconsin. And they ultimately settled the estate tax litigation at $40 million. Well, they used to own, and they also own the Catalina Island in Southern California. They didn't have enough cash to pay the estate tax, so they had to sell the Chicago Cubs baseball team, which they owned. And at the time in 1981, when they had to sell it, they got $20 million. But then many years later, in 2015, it was worth 1.8 billion. So they lost a whole bunch. And I hate to say it, but this estate tax was all gummed up because of their lack of planning. Yuck, yuck. I know, that's bad. Okay. Michael Jackson. He had a tax court case that was just resolved, and the IRS claims he owes $505 million. And another $196 million in penalties. Well, that's quite a lot. His estate continues to bring in a huge amount of money. They're $60 million advanced for a film, recording contract worth $250 million. And the problem with this lack of estate planning is that when you have income in an estate, you have to do a fiduciary tax return, a Form 1041. And it has the highest tax bracket. A trust gets into an estate, gets a maximum tax bracket at about $11,500, which if they distribute it to individuals, the tax bracket would be you'd have to be up over $335,000 of income. So a whole lot of income is being lost because of fiduciary income tax. Conservatorships, if you don't have a durable power of attorney for asset management, you become incapacitated. The only choice is that your heirs have to go to court and get a conservatorship. If the person's under 18, it's a guardianship. It's an expensive process, takes a lot of time, and all actions of the conservator are subject to court supervision. We had several other failures. One is we had a client with a trust. She named her daughter as a successor trustee. And when mom died, the daughter was alive. Several years later, the daughter had done absolutely nothing for the estate, and the daughter dies. And the trust had no way to appoint another trustee. There was no method for choosing another trustee, nor was another trustee listed. So we had to take the case to court in order to get a trustee appointed, and they really delayed a long time because it was 15 years after the mother had died. This next example was a neighbor of mine, Dave Alicante. He had 2 children. He absolutely wanted his 2 children to share half of his estate. So his son was helping him. And then after a while, the son says, well, let me help out here and I'll go on the title of the property as joint tenants. And then later the son suggested that it might be better if dad passes away that the son is on as a joint account holder for the bank and investment accounts. And the will or trust absolutely said they're supposed to split everything between the 2 children. When he died, nothing went to the daughter. She was completely excluded because joint tenancy transfers, they call by operation of law, are automatic. So that was a huge mistake, especially for the daughter. Oftentimes we'll see situations where somebody has done everything right, they've got their house in their trust, and then they go to refinance their loan. When they're done, I understand title companies are reticent about putting the property back because they have to be neutral between the lender and the borrower. So we find that houses after refi frequently don't get put back in the trust, which could cause a probate. And there's another abbreviated procedure that the courts devised in the case of Hegstead, where they treat a trust to be like a deed. There's a granting clause in the Schedule A of assets. It describes the property, and it was notarized. So they make a fiction, and instead of doing an entire probate, we can bring the situation to the probate court and ask them to put it in the trust, so we don't have to do a probate. But some judges won't do it. Another problem that could occur is, let's say you have children that go away to college and they have a medical problem at school and they can't communicate, and the parents want to find out what the medical condition for their child is. Well, the child's an adult, and the hospitals will not talk to them without a HIPAA release. So that's frequently part of the documents that we prepare as part of the Advanced Healthcare Directive. Yeah, this problem happened in my family. My mother's trust, she had a neutral family member being a trustee for years and years because of the neutral and level-headedness. And then my little sister, Holly, 3 weeks before my mom died, got to be put on as trust, didn't tell anybody. And then after my mom passed away, the sister went and cleaned out the trust and moved out of state. And there's been a huge amount of litigation since that point. And needless to say, we don't have togetherness at Thanksgiving. Another problem that occurred in my family, and I would not suggest anybody do this, my aunts and uncle, Mary and Faye, named 3 co-trustees. It was a recipe for disaster. The 3 trustees, 2 of them got along and 1 didn't. The druggie daughter sued the trust over and over and over and over, stole everything that she could move, and run up hundreds of thousands of legal fees. Eventually, she killed herself, and shortly after, her druggie daughter also died, which brings up a good point. Oftentimes, trust and estate disputes have to do with family problems. You took my bicycle when I was 6 years old and was mean to me or something. And so they've got this pent up frustration that comes out after the parents pass away. And the advice here is that psychologists are way less expensive than attorneys. So if you can get the family problems resolved in a psychologist's office, it's much better than in a probate court. Okay, so we've already talked about these 2 items. And the path of least resistance, which is doing a good estate plan, is the path of most allowance. So what we've covered today is what is a comprehensive estate plan and also how to mess it up. A revocable trust, 1 per couple. Make sure you put all your assets in the trust that you can. 2 pour over wills that point back to the trust for asset direction, 1 for each partner. 2 durable power of attorneys for asset management, 1 per spouse. And 2 advanced health care directives, 1 per spouse, end of life decisions, and a HIPAA release. So with that, we've come to the end, and I'd like to see if there are any other questions.
Did you want me to take those, Tracy?
Does anybody see any questions?
Yeah, can you hear me, Rex? This is Kathy.
Yes.
Okay, so I'll try to go back to see where Tracy left off. regarding asking some of the questions?
The last one that she asked was on durable power of attorney and joint bank accounts.
Okay. Did she ask about, can a boyfriend and girlfriend planning on marriage create a joint trust before marriage?
Yes, that was asked.
Okay. They wanted access to your slideshow. We've already done that. Okay. I think, how does Medicare affect assets in a trust after the trustor has died?
Oh, excellent question. I like that. I should have included that one. What happens with, it's called Medi-Cal in California. That's our flavor of it. It's not really Medicare. So what happens, and it's really important, if you have a will and then later you're brought into a care home and have to have Medi-Cal pay for your $5,000 a month living costs, when you pass away, if you have only a will and you go to probate court, Medi-Cal, Department of Health Services, will do a clawback and take every dollar that they gave you out of all your assets. So you qualify for it by not having a lot of liquid assets. They'll allow you to have a house, that's not included. But 2 years ago, they changed the law. And if you have a trust and you go into a care facility and let's say the Medi-Cal agency pays $600,000 for your care, when you pass away, Medi-Cal or Department of Health Services does not come back and take the assets out of your estate. So that's a huge advantage of a trust over a will if you own any property.
What do you do? Yeah, that was really good. What do you do if you have property in another state and other countries?
Okay, what happens if you have property in other states? In United States, you have what's called an ancillary probate unless they're in a trust. So if you had property in California, Idaho, and Texas, you're going to have 3 probates if you are only using a will. If you have them in a trust in any of those jurisdictions, then you can avoid probate. But it takes a lot of time if you don't do those right. And out of country, we limit our estate planning to the borders of the United States. Although Canada is very similar to the US, Mexico is way different. If you have out of country property, I always advise that the client get competent professional advice in that jurisdiction and do what they recommend for their local rules.
Okay. Back to a non-married, 2 individual doing a trust together. What do we call them when the software asks if couple of individuals? Not sure.
I'm not sure what the question is. What do we call the name of the trust or what?
I think, what do we call them when the software asks? I guess it depends on what software you're using for your trust, right? As far as what it would, what do we call them when the software asks if couple of individuals? So, you know, like spouse.
It's okay. I understand the question, but it's hard to answer because it's constrained within a software package that I don't know what it is.
What program do you use for your trust?
It seems to me that you would have both people listed in the question and answer. Presumably, if the software was constrained, you could put one person's name in, and then when the document was prepared, add the second name and draft around that problem. But I don't know what to say, what some software would do.
Okay.
There's no problem in having a trust with 2 unmarried people.
You may just have to figure it out. If there are 5 heirs in a trust and one of the heirs dies, can that heir's child inherit the deceased assets, or would the child have to open a probate lawsuit?
Okay, what we're talking about here is redemption, or things that are lost because of a distribution. When the trust is written, it should say, let's say there's 3 kids,
5.
and if it doesn't say that it goes to
Survivors.
the other surviving, if there's no direction to it, the assumption would be that it would go to the deceased children's children.
Okay.
And there's 2 different systems. One's probate code section 240, the other one's 246 and it's really complicated, but how that percentage divides out between heirs. But it's good drafting policy to make sure that you say that there's going to be 3 beneficiaries, and if they're not alive, then it goes to their children, or what happens in that situation. So there's not a default. You're in control of what you want to happen.
Okay. Can we use trust? Can we use the trust as a contingent beneficiary on life and annuities, if you like?
Yes,
Correct.
absolutely. A trust can be a contingent beneficiary. Let's say you have 1 child, and on the life or an annuity policy, it says that the child is going to be the beneficiary. And then if that beneficiary is not alive at the time it's supposed to be transferred, yes, you can have an alternate beneficiary to be the name of the trust. No problem.
Okay. Does putting one joint tenant's interest into a trust automatically turn vesting into tenants in common?
Okay. What happens when you transfer property into a trust, the character, that's what we call it. It's not a cartoon character, but it's the character of property, whether it's separate, whether it's community, the type of, that's what they call character. So oftentimes what we'll do is, let's say there's a husband and wife and they hold their property in joint tenancy. Most trusts say, in the trust law, if it doesn't say it in the trust, say that when you transfer property into a trust, it retains the same character. And if you cancel the trust and take it back out, let's say it's joint tenancy, if you put it in the trust as part of the trust. If you were to cancel the trust, it goes back to joint tenancy. So oftentimes what we will do is we will do 2 deeds. One for husband and wife, for example, from husband and wife to husband and wife as community property with right of survivorship. And then we will transfer that deed into the trust. If it's an unmarried couple, whether it's community property, whether it's tenants in common or it's joint, the same thing applies. The character doesn't change when it goes into the trust.
Okay. Don't unmarried partners have to redo the POAs and will when they marry? Doesn't a marriage or divorce invalidate the POAs and will that pre-existed by operation of law? Divorce?
It's 2 questions. One is, when we start talking about divorce, generally dispositive provisions are terminated on divorce. I have never heard of anything saying that when somebody gets married, it changes their agent under a durable power of attorney. I don't think it does. You've named an individual, and unless you conditioned it upon a marital status, I don't see where that would have a problem. But I would caution on, when couples are getting together and separating, that they look at their estate plan to see if there's any surprises they hadn't thought about. And maybe they do want to change their agent under a durable power of attorney.
Oh, so creating the joint trust, do you include community property language with trust?
Okay, when you transfer community property into a trust, it stays community property. Generally, a trust does not discuss whether it's community or separate. Usually what we're dealing with is it's known at the time the trust is funded. So if we had separate property from one spouse, it was already in their name as separate property. It would say from Susie Jones as her separate property grants it to the XYZ trust. So it stays the same. And it just doesn't change from that situation.
Someone would like to know where they can get the POLST, the POLST document.
The POLST is available online. I believe the state of California controls it. I've gotten them online and printed them out. You need to make sure that you put it on the proper color paper, which I think is pink, and have it, bring it to your doctor so that it can be properly filled out. But you just do a Google search for POLST and you'll find that form, and make sure it's for the state of California.
Someone was asking what software you use for your trusts.
I use California Wills and Trust from LexisNexis. We used to call it CAPS.
Right.
I know Jim Wilroy uses another software, and it's good too. I would caution when you get into software that is California oriented, because California's rules are so detailed.
Somebody wanted to know what you charge for your trust packages. I think they could just email you directly.
Yeah. Yeah, it's in the range of $1,600, $1,800 for an estate plan, a comprehensive estate plan, plus
Wow, that's really good.
$250 a deed, $250 a deed plus recording costs. And you get a whole lot of paperback. It's amazing how thick those get.
Yeah. Okay, does the property automatically fall out of the trust when a person dies? For example, a tax assessor automatically retitled taxes on property without being asked to do it.
Okay, that's several questions and a few misunderstandings. First of all, property tax is huge in estate planning, because if a parent dies, you can give the property to children and then get a parent-child exclusion so that the beneficiary keeps the same tax bracket, the same assessment with the assessor. There's a form called a parent-child exclusion. And there's another one that is not as well known. If they're co-owners of a property and they both live there and one dies, there's an exemption for reassessment for co-owners, as long as it was a resident, and that one's quite handy. So on death, the county assessors assume that the beneficiaries and its transferred title on death. And then the county assessor kind of waits and see what happens with the title over a period of time. And when title is given to the beneficiary, then they will look at reassessing. If it's sold, there's no problem because the property gets reassessed to the sales price. But there's a lot of problems in that area. We had one case where 4 children were the beneficiaries equally, and they devised the property for the house in Alameda County to one person. And the county assessor reassessed the property for 3/4. And so we had to go back and fight the assessor because the trustee did not have the authority to do what they did. And we got them to back down on the assessment, because if you mess up a property assessment on transfer of real property in California, it might cost you $10,000 a year forever. And the way that the property tax rules, its revenue and taxation code, starting at around section 63.1, it's really convoluted. And the way that the assessors work is they're real nice and smiley when you talk to them. And when property transfers, they wait like 8 to 10 months until everybody thinks everything's done. And then they start sending supplemental bills and start jacking the property tax up. So that is an area that needs close evaluation and proper documents.
Hey, this is a really long one, and it says it might be out of the scope of the course tonight, but what happens when the property is transferred into one trust, but the trust is later altered and the property is never transferred into later trust? The first trust gave the property to a beneficiary A. The later trust gave property to beneficiary B, leaving beneficiary A with only a life estate. Capacity to execute the latter trust may be questionable. Sounds like a bar question. No kidding. If this is not...
I understand the question. And first of all, you have one trust with one beneficiary as a life tenant, as a beneficiary. When you amend a trust, you generally will say whether you're going to keep the same provisions or change them. Like I mentioned earlier, we frequently gut an original trust, cancel the whole thing, and restate everything. And first of all, you have to see whether the right to amend the trust included the right to change beneficiaries. Some would not. And by amending a trust, it doesn't change the beneficiaries by itself. First, you have to have the right to change the trust, and secondarily, you have to have the right to change beneficiaries. And at that point, the beneficiaries can fight it out to see whether it was a valid amended trust or not. They're not usually considered separate trusts. If the first trust was canceled and the assets were transferred into a totally different trust, then you would have to look at that situation to see if they had the right to do what they did.
Okay, how can you find out if estate taxes are due?
Oh, good question. I should have covered that too. That's on a IRS form 706. And as Jim Wilroy pointed out, it's not inheritance tax. It's estate tax. Inheritance tax goes to the beneficiaries as their liability. But what happens now is if you have an estate for a single person over 11,580,000, you have estate tax due 9 months after the date of death. For a married couple, it's over 22 million. Then you have estate tax. For 99.5% of the population in the United States, you're not going to be seeing very many inheritance tax returns. We still do them. We've always done them. But they're getting rarer. In fact, IRS laid off most of their workers that were in the estate and trust area. And there are ways, there are trusts around. We frequently come across old trusts where people created a trust 20 years ago. They never updated or had anybody look at it. At that time, the inheritance tax was perhaps everything above 600,000, and then required a splitting of the trust on the first spouse's death. There's no reason for tax to have that type of arrangement anymore, but when a trust has it in there, the successor trustees are obligated to follow the trust. And the downside is that the trust is split into two parts. Half of it, they call it a bypass trust, gets a separate federal ID number and has to file a separate tax return every year, which might cost $800 to $1,300 or something like that every year until the second spouse passes away. So I always advise people, if you have an old trust done maybe more than 10 years ago, if you have a provision that calls for a splitting of the trust and your assets are lower than 11 million for a single or 22 million for married, get rid of that clause that causes a split into what they call an AB trust.
Okay.
Another exception on the inheritance tax, there's an unlimited marital exemption between spouses. So if their estate was worth 15 million and one spouse died, then all of the exclusion could go to the second spouse. And then when the second spouse died, then we would be looking at the 11 million as the starting point for estate tax.
Okay, somebody wanted to know if you could share a questionnaire to include the POAs and healthcare directives, instructions for medical. I don't know if you want to do that. You could maybe talk
I'm not
about,
sure I understand what the question is yet. There were several documents. I didn't know what they wanted done.
I think they want a copy of your questionnaire, and I know California Wills and Trust, you can print out their questionnaire, so maybe
Okay. We have several estate planning questionnaires, and we're trying to develop what we call the mother of all estate planning questionnaires that has all the good stuff. I'd be happy to send somebody one. The California Wills and Trust Estate Planning Client Organizer is about 47 pages.
Yeah, I know, it's very long.
It is very detailed. The one that we frequently use is one that we've adopted. It's 8 to 10 pages. And we're finding more and more that people don't want to fill them out. And we're going to the client in the office question and answer method because some people have an aversion. First of all, they don't want to admit that they're mortal and they don't want to get around to doing estate planning. And secondarily, they get thrown off by a whole lot of paperwork before they even get started. But if somebody sends us an email and asks for an organizer, we'd be happy to send you one.
Okay, I'm going to try to go through. So I think we could kind of wrap it up now. And for everybody that hung in there, they'll get an hour and a half of MCLEs.
Oh, great.
For staying with us. Are you ready? Are you willing to have anybody email you if they have any additional questions? And maybe some of these questions we can look over and pick up for the on the next.
Oh yeah, thank you for bringing that up. If
Okay.
I'm happy to answer questions, a short question or anything, you can call us at 925-934-6320. Email us at rexcrandell@astound.net. And we'd be happy to answer questions that you might have. We don't have any problem with that. Oftentimes we can give a quick answer to something, and we're happy to do that.
Okay, and if anybody else has any questions, they could always contact Tracy. She's always available to help. We appreciate your time tonight. Thank you so much. And do we have a date set for the part 2 yet?
Yes, we do. I don't know the dates, but they're the second Thursday of each month until December.
Okay.
For part 2 through 5.
Okay.
And the first presentation here was designed primarily to do an overview of comprehensive estate planning and what the documents did, how they interact, and teach people how to mess up their estate plan in ways they didn't intend. The other presentations are going to go into more depth
Right.
on specific subjects, like one on trust, one on wills, one on durable power of attorney, one on advanced healthcare directive. So they're going to be a lot more technical.
Great. I think that that's probably what everybody's needs right now. So, all right. I think we'll close for